international jurisdiction at the UPC, ex officio review, and why the 1 month deadline of Rule 19 does not apply. In the previous episode, we looked at the Court of Appeals clarification in Barco versus Yealink. Brussels I Recast governs international jurisdiction, while Article 33 UPC agreement governs internal competence. Today, I want to focus on a related question, namely who must raise and substantiate an objection based on a lack of international jurisdiction and when this must be done. In this regard, the Central Division Munich held in UPC CFI 252 out of 2023 that the UPC must examine its international jurisdiction of its own motion where this is required under union law. In particular in lease pendants and related actions situations under Article 29 to 32 Brussels I Recast. That obligation arose because parallel national proceedings were pending. In those situations, EU law requires the court to step in, even if the parties say nothing. But that does not mean the UPC must review every possible international jurisdiction issue on its own initiative. Therefore, the question still remains when objections based on international jurisdictions must be raised. In UPC CFI 162 out of 2024, the Mannheim Local Division made clear the international jurisdiction is not subject to the 1 month deadline in Rule 19 Rules of Procedure. Rule 19 does not limit when international jurisdiction under Brussels I Recast may or must be objected to. In other words, failure to raise an objection under Rule 19 Rules of Procedure does not cure a lack of international jurisdiction, nor does it prevent the court from examining international jurisdiction at a later stage or even ex officio where EU law requires it. Accordingly, objections to international jurisdiction may be raised in the statement of defense or even later, although late submissions remain subject to the court's general discretion on late filing. Thanks for watching and see you next time.